Thank you, thank you, thank you. Thank you so very much for joining me again today on the Elite Legal Landlords platform. My name is Julie. I am your legal friend. In my 16 years or so experience in property as a property investor, as a property coach, as a property solicitor, it still pains me. It hurts me so much when I see landlords leaving a lot of money on the table. They lose unnecessary, costly court battles because they are not educated, they are not equipped, they are not empowered to succeed in their journey from a legal perspective. So that's why I've set up the Elite Legal Landlords platform, a platform where we interact with other landlords to understand about our legal obligations, to understand about our tenants' obligations, to understand how to navigate lease options. You are now a landlord if you take on a lease option. You need to know what your obligations are, your rent to rent, all the other landlording things. Let's share these videos. Let's comment. Let me know what you want me to cover. I am here to serve you. I am here to help make a difference. I am here to help you prosper through property. I'm here to help you safeguard your investment, to help you make money, not lose money. Anyway, enough about that. Today we're going to be talking about the recently enacted Tenant Fees Act of 2019. What a pain, to put it bluntly. They said it was enacted to help protect tenants. Really? Protect tenants? It's more like it was enacted to penalize landlords. That's my view, and it's only just a view. And I'm sure I'm entitled to that. Anyway, the Tenant Fees Act 2019, effective from the 1st of June 2019 for all new tenancies created from that date. It also affects other tenancies that perhaps were fixed term before, and if you're renewing it for another fixed term post the 1st of June 2019, that again will be subject to the tenant fees ban. So just be mindful of that. I discussed this in a lot more detail on the full webinar, which I'm hoping you'll be able to register for. So you've also got a transitional period for those other tenancies which commenced prior to the 1st of June 2019. The obligations will only bite after June 2020. So you've got a period of grace to put your house in order. Utilize that to update your policies, to update your procedures, and to update your agreements. So which type of tenancies does the ban apply to? The ban applies to Housing Act tenancies. It applies to your assured short-hold tenancies. Your assured short-hold tenancies are, those standard tenancies where it's your primary home, the ones where you've perhaps got families there rather than a business, those kind of tenancies. And again, I will run another video series on types of tenancies, but for our purposes, assured short-hold tenancies apply. Things like your student lets as well, they fall under this heading. The ones that are not applicable are the non-assured short-hold tenancy ones, the non-Housing Act ones. So you've got your company lets, you've got your service accommodation agreements, those kind of agreements, they're the ones that don't actually apply. So the tenant fees ban has got quite a few restrictions on it. You've got restrictions as to the amount and the type of payments that you can require from a tenant. So you've got permitted payments and you've also got prohibited payments. So unless if a payment is expressly set out in the statutory instrument as a permitted payment, it will be prohibited. So some of the permitted payments are things such as your rent. How lucky are we as landlords to be allowed to claim for rent? That is a miracle we should be grateful for. So rent is a permitted payment. You need to be alert to the fact that you can't increase the rental without an upwards and downwards rent review clause in the tenancy agreement. You also need to have express and equivocal agreement with the tenant if you're going to increase the rent. But not just that, the law is pretty clear in the sense that you can't start with a low rent and then have a steep increase at the outset to cover for the loss of the other fees. So be mindful of that. Holding deposit you can, default payments you can charge for those. So if a tenant loses a key fob or something along those lines, you can charge for that. You can charge for council tax, you can charge for utilities, and a few other matters. So I will continue the series on tenant fee ban. I will talk about the prohibited payments. I'll talk about the impact on tenancy deposits. I'll talk about the impact on evictions. I will also discuss any other matters that you ask me in the comments. So whatever it is you need to know, just ask and I will be more than happy to cover that for you. You can also cover, I don't know whether I touched on it before the screen just kindly disappeared, for variation and assignment of a tenancy. So if your client asks or if your tenant asks for a variation of the tenancy, you can charge a reasonable fee and it's capped at £50. You can also charge for early termination of an agreement if your tenant wants to end the tenancy earlier, and then you can also charge holding deposit. I'm sure I mentioned that, but we know that the holding deposit is now capped at just 1 week. So yeah, I think that's covered most of everything I needed to cover for today. I am just so grateful that you've chosen to spend time again with me on the Elite Legal Landlords series of videos. If you haven't already subscribed, then feel free to do so. Otherwise, I wish you prosperity in your property journey. And remember, what you do not know could cost you. All the best.